Welcome to Law Sessions. I am Jennifer Housen. In this session, we will explore the requirement of consideration in any contractual arrangement. The general rule is that you will need certain requirements in order for there to be a valid contract, not least that there is an offer, that there is acceptance, that there's an intention to create legal relations, that the terms are certain, and indeed that consideration is also present and that the whole thing is supported effectively by consideration. We have certainly looked at the other requirements, and what we will focus on here is the whole requirement for consideration. One preliminary point to note, of course, is that if you are looking at a promise under deed, then the requirement for consideration is not necessarily needed. Precisely because it is under deed, the common law will give effect to it even in the face of there being no consideration. Outside of that, though, let's consider what it is that we're talking about. Well, when you consider a working definition of what consideration is, consideration for a particular promise exists where some right or interest or profit or benefit accrues or will accrue to the promisor as a direct result of some forbearance or detriment or loss or responsibility that has been given or suffered or undertaken by the promisee. In a nutshell, there must be give and take. There must be something from my side, and there must be something from yours if we are the parties in the contractual relationship. Now, consideration can either be executory or it can be executed, but it cannot be past consideration. We will, of course, explore those shortly, but briefly, when you consider, for example, I decide to sell you my pen. Now, if it is that I say to you, I am going to sell you my pen, you and I have agreed, but I have not yet given you the pen and you have not yet given me the money, well, the consideration in respect of the property is executory because we have not yet done it. If it is that I say to you, I'm going to sell you my pen and you're going to pay for it, and I give you the pen, then my giving and you now receiving it is, of course, executed consideration as opposed to executory consideration. It has also been described as a benefit to one party or a detriment to another. Equally, that it is a price paid for a promise or the element of exchange. The most definitive, in my view, definition that has been advanced is set out in the case of Curry and Meiser in 1875, which certainly looks at the requirement as being that consideration requires that there be a valuable consideration in the sense of the law. It may consist either in some right or interest or profit or benefit accruing to the one party or some forbearance, detriment, loss, or responsibility given, suffered, or undertaken by the other. So certainly, in my opening, we're looking at what Curry and Meiser has had to say about it, and arguably that is going to be the best working definition. Well, as I said before, two types you have, of course, are executory and executed. Promise to do something in the future is executory consideration. Executed consideration, of course, is where an act has only been performed at the time the contract is entered into. Now, past consideration is something where it has already been completed before the promise is made and cannot amount to consideration. So if I say to you that I am going to, for example, help you with your contract law exam, and you should come to my house and we will go through half a dozen lessons for it. And let's say you come to my house and I give you the half a dozen lessons and you think, wow, you're an absolutely fantastic tutor. And you decide just for that, I will pay you £50. Well, you aren't thinking that I'm that fantastic, but you decide to pay me £50. Now, the fact that we had not agreed the £50 in advance and the fact that we had not intended that there should have been any payment, I had simply offered as a friendly gesture, and then you later on said you would pay me for it, then of course, if I were to bring an action against you for the £50, that would certainly be past consideration. And as it relates to past consideration, relevant cases, of course, are Roscola and Thomas. In the case, Thomas sold a horse to Roscola for £30. After the sale, Thomas promised that the horse was free from vice, which was not true. It was that Roscola could not sworn the promise, as he had already agreed to pay for the horse when the promise was made. The fact that it was free from vice was not necessarily the thing that was of concern to him. These cases always interest me because I always think of whenever these horse stores, I always think that it is a time when it was the equivalent of us buying a car now. But nevertheless, if you look at Ray McCardle, again, good case to quote, for example, if you're doing anything on past consideration, it is a situation where it provides in the case a promise was made to pay money in return for past services. It was held that this was past consideration and it was therefore invalid. Now, that's not to say that there cannot be a situation where there is past consideration and the court doesn't uphold it, because there may be a situation where the court upholds that, albeit that it is past consideration, we will allow it. Well, where a service is rendered at the request of the promisee on the understanding that a payment will be made, a subsequent promise to pay a certain sum will be enforced, and that is provided the payment would be legally enforceable if it had been promised in advance. Case, of course, is Lampley and Braithwaite in 1615. Braithwaite had killed a man and he had asked Lampley to do all he could do to get a pardon for him from the king. Now, Lampley did this at great trouble and expense, and Braithwaite promised him £100, but then refused to hand it over, claiming that Lampley's actions were past consideration. It was held that Lampley was entitled to his money as he had done the act on Braithwaite's request, and it was clear at the time Braithwaite asked him for help that he would be paid for his trouble. Now, this has been encapsulated in the principles set out in the Privy Council case of Pawan and Lau Yu Long, and it laid down the 3 conditions which must be satisfied to invoke the doctrine of Lampley and Braithwaite, and they are these: that the act must have been done at the request of the promisor. The act must have been understood that a payment was to be made for the service when it was requested. The contract, had it been made in the normal way, must have been one that was legally enforceable. Now, how does this translate generally on an exam? Well, the thing is, again, let's go back to my example where I'm saying to you that I will assist you in ensuring that you prepare, for example, for your law exam. Well, if it is that my sole job is tutoring and I run a private tutor service, for example, then the fact is, if you telephone me and say, can you give me some private tutor lessons? And I say, oh yes, most definitely. When would you like to come? And you say, well, can I come next Monday, please? And I said, certainly. And you turn up and we start the sessions, and at session 6, I hand you an invoice and you say, well, hang on a minute, I didn't know you would charge for it since you never mentioned it. Well, I would turn to you and say, well, hang on. Pawan says I can based on the doctrine in Lampley and Braithwaite because you requested it. And also, you know that this is the kind of stuff that I do. You know that this is my job and I don't do this for free, as it were. Now, if you're able to show the requirements in Pawan, then arguably there is sufficient there for the fact that you could enforce any claim for the consideration, because the fact of the matter is that it is one of the circumstances that the courts will allow past consideration to, of course, be enforced in those kind of circumstances. Now, in the area of consideration, there are some rules which are relevant, and there are some rules which govern consideration. We will look at these rules in turn. The first one is that consideration must move from the promisee. And what that means is that a promise is enforceable if it is supported by consideration. So what that means is that where consideration has moved from the promisee, then it is enforceable. So for example, if we look at the case of Twiddle and Atkinson, John Twiddle promised William Guy that he would pay a sum of money to the child of William Guy, and likewise William Guy promised to pay John Twiddle a sum of money to his child upon the marriage of their two children to each other. However, William Guy failed to pay the son of John Twiddle, who then sued the executors of his estate for the amount promised. It was held that the son could not enforce the promise made to his father, as he himself had not actually given consideration for it. It was his father who had done so. Now, the fact is that consideration must move from the promisee means, and this is what I want you to understand, because again, sometimes because of the misunderstanding of the concept, people get it slightly wrong. The fact is, consideration must move from the promisee means the person who is seeking to enforce the promise must have given consideration. The person seeking to enforce the promise must have given consideration. So, if I say I'm going to sell you my pen, and you're going to pay £10 for it. If it is that I give you the pen and you don't pay me, then because consideration has moved from me, I have given you the pen, then the person seeking to enforce the promise, me, I have given consideration. Equally, if it is you gave me the £10, but I don't give you the pen, you are the one who's seeking to rely on the promise, so consideration must have moved from you. The reason I say that it does cause a little bit of conflict is that sometimes law students look at the property from one person and just believe, oh, it's the person on one side from whom consideration must move. But it's not really. It is the party who is seeking to enforce the promise must have provided consideration. Of course, the idea of privity of contract, which we'll come to later on, is certainly underpinning this area, because the idea is, if you do something for me, but you say that I should pay X, and then X seeks to sue me, then X has not provided consideration to the extent that consideration has not moved from X. Now, this particular rule of consideration forms the basis, as I said, of the doctrine of privity of contract. That is, only a party to a contract is permitted to sue upon that contract terms. But please bear in mind that the doctrine of privity has somewhat been altered by the Contract Right of Third Parties Act. Therefore, consideration from the promisee was such that if he had not provided consideration, he could not claim upon it. However, under the Contract Rights of Third Parties Act, we see that the legislation now is that if one party has a contract made which is for his benefit, even if he is not a party, then that party who has the benefit under the contract can certainly seek to enforce it. And as such, it doesn't necessarily have to move from him. Now, I will reiterate again that only a person who has provided consideration for a promise can enforce it, because I need to then move into the case of Dunlop and Selfridge. Because in Dunlop and Selfridge, a 1915 case, and this was a case to do with tires being sold, and the point here was that the person selling the tires wouldn't sell it for more than a particular price, but then he sold it on to someone else, but that person decided to sell it for less than was agreed. And what the court said there was that an act or forbearance of one party or the promise thereof is the price for which the promise of the other is bought, and the promise thus given value is enforceable. And that is where the court's position came on that. Now, there is, of course, another very important rule in relation to consideration, and that consideration need not be adequate, but that it must be sufficient. And we will now take a short break, and immediately on our return, we will consider that point.